Welcome back. Now, the South African Private Practitioners Forum has filed its application in the High Court in Pretoria. In this, asking the court to review and set aside the President's decision to sign the NHI Act into law and declare it invalid. CEO of the forum, Dr. Simon Strachan, joins us now to unpack the legal action. Thank you so much for your time, Dr. Strachan. Now, in your view, what makes the NHI invalid from a legal standpoint?
Good evening. Thank you for this opportunity. Yeah, so we think it's important that we do challenge this. And I think it's important that this challenge is directed not just for our colleagues who are healthcare providers, but for our patients to understand that we as healthcare providers are concerned. And we're concerned on a legal basis, first of all, to the President assenting to the bill. So our challenge has got two aspects.
Okay.
The first is on the procedure. And we are asserting that the President didn't follow his constitutional duty. And that duty is that if there is any legislation placed before him for which he has any constitutional doubts or concerns, then he should be referring that to Parliament. And we assert that the President either did know or certainly ought to have known that there were serious constitutional concerns about this bill as it was at the time, and not least because the organization, the South African Private Practitioners Forum, SAPPF, were co-signatories to a very detailed document sent to the President in December 2023, outlining all of these constitutional matters.
Yeah.
And in that procedural challenge, we then also require the record, in other words, the information that the President had at his disposal to make this determination that eventually led him to assent to the bill. So that's the first part, that's the procedural element. And the second part of it is the constitutionality. And we have concerns there because we believe that the Act, in fact, unjustifiably limits a number of constitutional rights, not the least of which is the right to life, the right to health care, the right to bodily integrity and security, the right to freedom of profession, and the right to property. Now, as you can see in that list, this is not just about the doctors, this is about patients as well. We also have concerns that the Act is extremely vague and providing no details regarding key aspects of how the scheme will be implemented, and that vagueness that makes it unconstitutional. And then the third part of our constitutional challenge is the fact that the Act leaves or allows huge discretion to the minister, the board and committees of the fund to actually make legal determinations and to enact things. And this is impermissible in terms of constitutionality, that you delegate this lawmaking functions to the executive of any organization.
Yeah.
So that's really what it is. It's about the procedural aspect and it's about the constitutional aspect.
All right. Dr. Strachan, also, I mean, before going to court, what were the conversations with government looking like? What was the mood there?
Well, we've participated from the outset, from the very first green paper. We've participated in submissions. We've participated not just in written submissions, but in submissions to the Parliamentary Portfolio Committee of Health. That was a live presentation, to the National Council of Provinces. We've been vocal on TV and in the media, but we've never actually had the opportunity to sit down with the department and say, can you please either hear us or acknowledge that you've heard us, which also would have been good, but we're at the point now of going, we can't leave this. I mean, this is now on the statute books, and we can't have this going on forever and ever, trying to enact something which we believe is just not possible to work. So what's open to us now is to challenge the Act. We've said this again and again, and it's important to say repeatedly that this has got nothing to do with the need for health reform, with our acknowledgement of inequalities, with our acknowledgement of the difficulties in health reform. We are 100% behind access to universal health care, equal access, good quality health care. We have always been available to sit down and talk and negotiate. And we do. We don't think there's ambiguity in separating that from the Act itself, which, remember, the Act is a funding mechanism for a system of healthcare. And it's that we don't believe is workable.
So you've outlined all the issues that you have with it, what you don't support, but you're basically saying that you agree with the overall objective of what an NHI should do.
Well, any form of funding mechanism, you see, the NHI doesn't have to be a single payer, single procurer model. It doesn't have to be that. The national health insurance can take many forms and can be far more fiscally appropriate for South Africa. That's really what the point is.
Yeah.
The point is, let's find that system. You know, and not only did we participate in dialogue and in submissions, but we and many others in their submissions actually had alternative structures, alternative proposals.
Okay.
And we were never called upon to please explain or let's have a chat about that. That never happened. Hence, here we sit now at this juncture.
Yeah. Would you actually say that at this point, I mean, breaking the impasse should be easier than what you have seen so far?
Well, breaking the impasse means there has to be a huge amount of concession from both sides. I mean, in the private sector, and that's the sector that we predominantly represent, I mean, we are fully aware that we need to get our house in order.
Yeah.
You just need to look at the health market inquiry recommendations. We all accept that those need to be put in place. But it's going to require a huge amount of concession from both sides.
Yeah.
You know, with the bill now being an act, that it is much more difficult to turn that around than it would have been if it was a bill. So to turn that around, I mean, that's not just going to mean sit down and let's have a chat and let's come up with some new plans and ideas.
Yeah.
It is an act. It has to go back to Parliament. It has to be amended. Or if the court cases go against the government, remember the respondents in our case were the President, the Minister of Health, the Minister of Finance and the Treasury. If it goes against them, well, then the act is not invoked anymore, and there is no longer an act, and then that has to go back to Parliament. So, yeah, it's so how can I put it?
Yeah.
The time to sit around the table and to come for a more amicable kind of arrangement.
Well, thank you so much for your time and for your insights concerning the legal action that the SAPPF has put forward against the NHI Act. That was Dr. Simon Strachan, CEO of the SAPPF.